Thank you, Madam Chairperson. I stand here to participate in the discussion relating to the amendment that has come to an Act of 1956, which is called Interstate River Water Dispute Amendment Bill 2019. And I can say already more than half a dozen amendments have come in between last so many years, 63 years to be specific. The amendments have stuck to a template which relies exclusively on tribunals for expeditious resolution of river water disputes. The Supreme Court and other courts do not have jurisdiction over such disputes. They can interpret verdicts of tribunals. This arrangement demonstrates that the disputes resolution generally has not been very effective. Disputes have recurred. There have been long delays in adjudication, and states have not complied with verdicts of tribunals. This bill has provisions to break that mold. Therefore, Biju Janata Dal supports this bill. I had opposed the introduction of this bill at the introduction stage because states were not consulted. That was my point of view. But the minister categorically stated that yes, consultation had taken place in 2013. I believe him. When I was saying that Supreme Court does not have jurisdiction, I was referring to the deliberation in the Constituent Assembly. And in that deliberation, it was repeatedly stated that there is a need to allow the Supreme Court to come into dispute resolution mechanism. But it was left to the Parliament to take a decision in this regard. And subsequently, one can say after 7 years, in 1956, the Parliament took a decision that it is better that individual tribunals should be there to decide on a dispute relating to water distribution. Madam, this bill proposes a permanent interstate water dispute tribunal. This tribunal will be 8-member body comprising a judge of Supreme Court or Chief Justice of the High Court who would be chairperson. A retired judge or a Chief Justice of High Court can also become chairperson. Similarly, the judicial member would be or has been a judge of a High Court. So this has been also is widening the scope. Already some members have spoken about that retired Chief Justices, retired judges of Supreme Court and also of High Court can become the chairperson and also the judicial member. They shall hold office for a period of 5 years or till the age of 70 years, whichever is earlier. No member shall hold office after the age of 67 years when we come to the other part of it. Each dispute will be referred to a 3-member bench and resolution will be time-bound. At least on paper, the entire process is restricted to 5.5 years. However, there is almost no limit on extensions in the current arrangement. These measures can improve the efficiency of dispute adjudication. The bill provides for Disputes Resolution Committee to enable ex-ante negotiated settlements in place of earlier mediation by the center. This is an interesting provision, but its benefits will depend on the mechanism's efficiency. The bill says the center will set up DRCs with members from such relevant fields, within quote I say, members from such relevant fields as it deems fit for resolving the disputes amicably, unquote. This definition is broad-based, but the DRC's functions, recording data, noting stands and claims of states, and reporting facts. Unless the DRC is adequately high profile and commands credibility and legitimacy for negotiated settlement, it may be relegated to performing perfunctory procedures. Madam, the other much touted provision is about data bank and information system. This is nothing new. There is similar provision in the current act as well, but this mandates the center to create a repository. The experience in this respect has not been very encouraging, but the challenge is not gathering data and information, but more about states agreeing over a particular piece of data. I think member from YSR Congress also has referred to, because there are disputes relating to data that is provided. And the challenge is, you know much better, as you argue a case before a court, it is the data that is always challenged. The challenge is about tapping the data to produce knowledge that can be used to produce knowledge that can be used for decision making. Such knowledge has been a major area of contestation before the tribunal so far. Even then, I would say this bill holds promise for tightening and improving adjudication. But some practical questions remain unaddressed. How does the bill propose to address the challenge of implementing the tribunal's award? Kaveri Water Dispute Tribunal Award, given in 2007, is yet to be implemented. The ambiguities will persist even after these amendments. The power to devise such mechanisms is with the center, but the government is ill-equipped to offer competent and resilient mechanisms. The River Board Act of 1956 has become a dead letter. The ad hoc mechanism like River Authority Supervisory Committee have proved ineffective. With this critical gap, implementing tribunal awards will be a huge challenge. Are we not aware that conflicts arise when the instruments and institutions for cooperation fail? A grave omission is the absence of an effective implementation mechanism. The decision of the tribunal will be final. And here I would like to explain it in a bit detail. And binding, the decision of the tribunal will be final and binding on the parties involved in the dispute. It will have same force as that of an order of the Supreme Court of India. Are we not aware that Supreme Court has been amenable to special leave petitions which then lead to extended litigation in the apex court? All this defeats the basic purpose of the reform to expedite resolution of river water disputes. Sir, in 1956, an amendment was given effect to in 2002 during Atalji's prime ministership. And it so happened that one of our senior members from Biju Janata Dal was heading at that point of time the Water Resources Ministry. And he had given effect to two major amendments in 1956. And it is relating to decision of the tribunal shall be final and binding on the parties to the dispute and shall be given effect to by them. These are the words which was mentioned there. And this was given effect to in 2002. And another proviso also was added. The decision of the tribunal after its publication in the official gazette by the central government under subsection 1, shall have the same force as an order or decree of the Supreme Court. And the same thing has been repeated, but the wordings have been little bit changed, that final and binding. In section 6, subsection 6, it is mentioned the decision of the bench of the tribunal shall be final and binding. Even under the present law, a tribunal ruling is not meant to be overturned by the Supreme Court. What does this final and binding really mean? I would like to understand from the minister. And in practice, Supreme Court has admitted review petition on the final award of Kaveri Tribunal. It even instructed Karnataka, yes, madam, to release water from time to time. So where is the finality of the decision of the tribunal? I would say still large number of gaps are there, and therefore I would say what at one point of time from University of California noted in their paper on India's interstate water disputes, there are too many options and there is too much discretion at too many stages of the process. This is partly because of the procedural complexities involving multiple stakeholders across governments and agencies. But the inchoate nature of the system is equally the result of factors outside the efficient functioning of the tribunal. Madam, it was in 1935 Act where all this dispute resolution mechanism had already had trickled down and went up to the Supreme Court, and it limited the jurisdiction of the federal court in 1935. And we are still continuing with that process. Should I request the government, why have tribunal? Let us send it directly to the Supreme Court. Let Supreme Court adjudicate. Instead of having a tribunal and to find a solution between two states, which never happens because now the political situation has changed. At that point of time, there was one party which was encompassing the whole country. Today, regional parties have come up, regional aspirations have come up, and we have coalition government in the union. It is necessary now to have a holistic view. Let us send, because ultimate adjudication is being done in Supreme Court of India. Why we should have this type of adjudicating mechanism like tribunal, and we'll support this bill, no doubt. It will be binding, it will be final, but ultimately it is not final at all. Because SLP, as you know, is being entertained by Supreme Court. And there is always a provision that yes, if I'm not satisfied with the decision of the tribunal, I have a forum to go and plead. With these words, I conclude.